So at every good road transport conference, there has to be the slide on the latest casualty figures to be reported. Year on year on year, generally that this is a downward trend, despite the arrow to the left. It's generally declining. And if you look at causation, it's usually avoidable. It can be loss of control, it can be driver fatigue, but a lot of these collisions are avoidable, which is where the crisis management theme comes in. The old adage, prevention is better than cure. I remember someone I worked with many years ago saying, what are the prospects of us persuading operators to come in and see us before it's all gone horribly wrong? And I laughed and said virtually zero. But I mean, that was 10 years ago. And increasingly now, people do come to see us at a much earlier stage. The first letter, the first trigger point, they've had a roadside stop. And I think that is a positive thing. So, of course, all of this is about trying to persuade operators to move from a reactive approach to a proactive one. I've just given some examples there. I'll start with a case I did. One of the very first cases I did in the magistrates' courts nearly 20 years ago. And it was a young driver. He'd come down a country lane in his vehicle, not a HGV, comes around the corner, and he causes a horse to startle that ended up in the ditch and had to be put down. And he was prosecuted for careless driving. Now, 20 years ago, we were able to persuade the magistrates that although the outcome was sad and tragic, in fact, it was the manner of his driving that was important, and the rest the magistrates should put out of their minds. Because he wasn't speeding and there was no other evidence other than the outcome of a careless approach to driving, he was acquitted. But I don't think he would be now. I think in the last 20 years there's been a huge shift from looking at the standard of driving to looking at the outcome, looking at the collateral damage. And that has been instructive to judges in deciding sanction, outcome, and sentence. These offences in relation to careless driving just didn't exist 20 years ago. But now, if you cause death, serious injury by careless driving, the sanction has significantly improved. And you may think, and so it should. But of course, if you are the driver and your standard has fallen below the requisite legal competency, that can be a relatively minor breach of the highway code, a momentary lack of attention, an unsafe manoeuvre. But if the consequences are significant, then you can expect a significant outcome. And I've seen a similar shift, not a shifting sand, but a complete shift in operator licensing. Similarly, years ago, your lorry went for a service. Now it goes for a PMI, a preventative maintenance inspection. You are trying to isolate not just defects where things are bust and broken, but things that are starting to show signs of wear, symptoms, and those should be recorded. The walk-around check has taken on an even greater significance. It would be not that unusual 10 years ago even for someone not to have heard of a driver walk-around check. I remember a chap coming to see me and he covered the whole desk with 50 driver defect books and proudly announced there was not a single defect in any of them. I didn't need to check. None of them had any defects, and he thought this was a good thing, obviously. And I had to explain the whole purpose of having this system is that drivers can use it to record a defect before it happens roadside. Same on monthly checks. Operators are encouraged to bring people in on a monthly basis to check tyres, things like that, before it's flat or before there's a blowout on the road. We've heard about earned recognition. There's a leaflet in your bag. Years ago, there were only audits. You'd have someone in, they'd audit the system that you had in place, and now we're talking about auditing or earned recognition. Go on to a system that's managing and monitoring you constantly. These are a couple of the cases that have cemented that change in the way traffic commissioners were able to look at outcomes. Mr. Turfitt might remember 15 years ago, advocates, not me obviously, would trot up to hearings, same old, but look at where we are today. Today, they're very good boys. They've done everything they've been advised to do, and you could expect a relatively light touch if by the day of the hearing you had your ducks in a row. But very gradually, traffic commissioners have been encouraged to take a preventative approach. They don't have to wait until something dreadful has happened to work out who is likely to be an offender. Randolph transport is used often in hearings because what that cemented is that traffic commissioners are not only able but should be looking at past events in determining outcomes. So, what can you do to avoid a crisis in your business? You've heard quite a lot about policies and procedures because it's important and because you would not believe how often it crops up. A lot of people come to see us with policies and procedures in a book that they've been given or that they've bought on the internet. There are a number of companies that will simply supply a book that you can take home. And a lot of operators, of course, may never open that without realising they've got to be rigorously applied to their business because, as Chris said earlier, if your policy is 2 or 3 mil on tyres and you produce lots of PMIs to show they're at 1.2 and 1.6, that's fairly good evidence that you think you should have a policy at 2 or 3 mil and you don't. There is a process as well, I would suggest. It's not just about having the policy and the procedure to be applied, but about making sure everybody knows about it. So in that example, you need to make sure your maintenance contractor knows your policy is to change tyres at 2 mil. If your drivers don't know what your policy is on tyres or anything else, they're not going to implement your policy. So after the policies comes the training. We hear a lot about toolbox talks, and that's just revisiting issues in the business on a regular basis. And I'm afraid that has to be pretty much continuous. When there's an issue roadside, an operator might say, I don't know how that happened because I gave him a toolbox talk on that 2 years ago. I mean, 2 years ago is too long. You have to be constantly reminding people what their obligations are until it is the culture of your business. And it doesn't end there. Lots of eye rolling. You have to then make sure that they're doing it. It reminds me of my children in some ways. You've got to do your homework, that's the policy. Yeah. So I'm going to create a rule, half an hour on a Monday, you've got to do your homework. Yeah. But if I don't check he's done it, the chances are he probably hasn't. So in addition to all of the above, you then have to check it's being done. And how are you going to achieve that? Through gate checks, through auditing, through regular touch-ins. What it is, overall, is just good management. And you're going to hear from the Traffic Commissioner this afternoon about the importance of good management in your business. So when should you tell the traffic commissioner that you have been involved in an incident? This is the low-hanging fruit, as it were. When this happens, you know you've got to tell the traffic commissioner about it. So you've had an S-mark prohibition, a load loss, wheel off. All these things are significant safety issues in the business. You have to notify. We receive calls almost every day about these issues. Cautions, fixed penalty notice, got done for speeding, convictions, when are they notifiable? And I'm afraid, much like my colleague Mark Davis this morning talk about exemptions and derogations, the rules on this, I'm afraid I don't think are very clear. We generally look at it on a case-by-case basis. Cautions, of course, are spent at the point they're delivered. Convictions can work the other way. So what we see sometimes is people being cautious about reporting. Report everything, just in case it's notifiable, because they're not sure how to apply the rules. But then, of course, you can have a spent conviction that occurred many, many moons in the past being the subject of a hearing, because, of course, if the traffic commissioner is aware of the matter that you've notified, they are then duty bound to examine it. They're the notification requirements. If you weren't already falling asleep pre-lunch, you would be if I read that out. So the only point to make there really is that the rules are, I don't think, are straightforward. Mr. Turfitt may disagree with me. There is a list of material that you ought to notify, matters affecting good repute, and of course you have 28 days in which to do so. So when the worst happens, we encourage people to investigate those incidents, and that can be everything from an MOT fail to a prohibition to a wheel off. When something's gone wrong, it can be instructive to understand the underlying cause, because it will prevent repetition. Now, we'd be out of business if everybody did this well, so I say this with some degree of trepidation, but we do encourage everyone to bottom out what actually happened, what actually went wrong, because if you can identify that, then it probably won't happen again. So consider notification, begin your investigation. Shameless plug, consider legal advice. Any advice we give, of course, is subject to legal advice privilege, as Catherine was saying earlier. So in the course of an investigation, those conversations and advice are confined to those parameters. For every 10 operators I go to see post-incident, 9 will spend quite a lot of time trying to convince me that the cause of the incident was driver error, almost invariably. And in a few cases, it is. But in most of those cases, it is a combination of driver error and poor or inadequate management. It's an environment where you don't have that triple combo that I described earlier of having good policies on it, which are tested, which are implemented, and which are checked. You cannot rely solely on the driver to make big decisions about whether or not an unusual or abnormal load is secure without having the benefit of specific training. It's normally a combination of something which the driver has missed, because let's face it, they all stop at that. That's the ultimate wall, isn't it? And so invariably they should identify a loose wheel nut, a load which isn't secure. But it's not just their responsibility. It is also your responsibility to make sure they know how to secure that load, because they've seen it done before. They know what the tie-down procedure is because it's published and they can access it. There's someone on the end of the phone that can check, or someone to oversee it. There's a gate check, a form, an audit, something. It's not just left to the driver to decide. I went to a wheel-off incident not too long ago. When I arrived, said, "You started your investigation?" "Yes." He said, "I need this to be the tyre fitter's fault." Okay. So if you approach your investigation in that way, ultimately at the end of his investigation, he's probably going to find it's the tyre fitter's fault. But a year down the line, whatever did actually cause that incident is very likely to happen again. And I strongly encourage people to actually approach this independently and impartially. Try to work out what actually happened. Interview everybody, record it, take your pictures, consider someone independent and impartial coming in to investigate on your behalf and record it accurately.